You asked us to look into the realities of independent work in Mexico and looking through this stack of materials you sent over. So the civil codes, tax framework guides, labor dispute case studies. One thing is immediately clear. A firm handshake, well, won't protect you here.
No, not at all. We are dealing with a landscape where good intentions and verbal agreements are just a massive liability.
Yeah, so today we're taking a deep dive into the source material behind the legal backbone of Mexican freelancing.
The professional services contract.
Exactly. Our mission is to unpack how this document acts as a vital shield for both freelancers and businesses. And, why getting it wrong leads to some serious financial nightmares. So let's unpack this. What exactly is this shield made of?
Well, it's built on the Federal Civil Code, specifically Articles 2606 to 2615. But beyond just citing numbers, the sources emphasize that for this contract to actually work, it requires non-negotiable clauses. We're talking a crystal clear scope of work, fee structures, confidentiality, intellectual property ownership, and jurisdiction, meaning explicitly stating which civil courts handle things if the agreement, falls apart.
I'm really glad you highlighted the scope of work there.
Yeah.
Because going in with just a verbal agreement it's like handing a contractor a blank check and asking them to just fix the house.
Oh, absolutely. Yeah.
A clear scope of work is the blueprint. Like, it dictates exactly which walls get painted so you don't end up paying for a new roof you never even asked for.
Right. And what's fascinating here is how the law actually enforces that blueprint. A written contract creates true legal certainty by defining those boundaries. And crucially, it acts as an executive title.
Okay, wait. Which means what exactly, in practice?
It means if a client refuses to pay you, that piece of paper makes judicial collection significantly faster and easier. You aren't arguing in court over what was verbally promised. You are simply enforcing the written terms.
Okay, let me stop you right there. Let's say I'm a business owner, right? And I have a freelancer sign a document that explicitly states independent contractor in big, bold letters. Isn't my business totally legally insulated by that piece of paper?
You would definitely think so. But, no.
Really? Why wouldn't that hold up?
Well, this raises an important question about how the contract plays out in reality versus what's just written on the page. Because the ultimate legal test isn't the title of the document. It is a concept called subordination.
Subordination, meaning who is really the boss?
Precisely. So the authorities look at the behavior, not just the paperwork.
Got it.
If a company requires you, as the freelancer, to clock in at a specific time or assigns you a permanent desk or issues daily, direct orders, the authorities will look right past that independent contractor label.
Oh, wow. So if it walks like an employee and talks like an employee, that civil contract is essentially void.
Exactly. They classify it as a disguised labor relationship, and that triggers massive penalties. Suddenly, the company is on the hook for years of standard employee benefits. So IMSS, the National Healthcare and Pension System, plus Infonavit.
Which are the mandatory housing fund contributions, right?
Right. Not to mention paid vacations. True independence means the professional dictates how the work is done. They use their own tools and manage their own time to deliver a final result.
Okay, so the government can strip away the freelancer label and force a company to back pay major employee benefits. With that massive financial sword hanging over their heads, why do businesses risk using these contracts at all?
Well, because when executed correctly, both sides actually come out ahead financially. If we connect this to the bigger picture of the tax code, businesses love this setup.
Because of deductions.
Exactly. The fees they pay are 100% deductible, provided they get a formal, legally stamped invoice known as a CFDI.
Right, okay. And for the independent professional.
They get to deduct their own expenses, like internet, rent, equipment, things a standard salaried employee just cannot touch.
Oh, that makes sense.
But to encourage freelancers to actually enter the formal economy instead of working under the table, the government offers a massive carrot, the Resico tax regime.
The simplified trust regime.
Right. Under Resico, your income tax plummets to somewhere between just 1 and 2.5%.
Wait, 1 to 2.5%? That is a serious boost to cash flow. There has to be a catch.
Oh, there is. The catch is the administrative burden. The government essentially forces corporate clients to act as tax watchdogs.
Interesting. How so?
Well, the professional has to charge a 16% VAT, manage their own accounting, and have those corporate clients withhold a portion of their taxes directly. So it's a trade-off.
Freedom isn't free, but it sure can be tax efficient if you know how to navigate the system. So To wrap this up for you, a solid professional services contract protects your autonomy, clarifies the tax mechanisms, and prevents incredibly costly labor disputes.
Exactly. It builds the legal fences so everyone knows exactly where they stand.
But it leaves us with a really compelling tension. As the gig economy grows and remote work continues to blur the lines of the traditional office,
Yeah.
we have to ask, how much day-to-day control is a company truly willing to surrender just to keep a worker legally classified as a freelancer instead of an employee?
Right.
It's definitely something to think about the next time you're about to shake hands on a new deal.